Good morning, Mr. Grossberg.
Thank you, Susan.
Morning, Your Honors. Bernard Grossberg for the defendant appellant, John Stote.
I have one question first, Mr. Grossberg. After reading the briefs, I'm a little confused. Maybe I'm just missing something. I thought the single justice permitted the case to proceed on only one ground, and that was the potential conflict of interest with the assistant district attorney. I think Ahlstrom is her name.
Yes, Your Honor.
But in your brief, you continually, I read it as referring in great deal to also Assistant District Attorney Diane Dillon, and I didn't understand that. That confused me.
Well, the defendant finds himself in a circular posture procedurally. The single justice allowed the defendant to appeal what we might call the second relationship, the intimate, what I call intimate relationship between trial counsel Walsh and Ahlstrom, who was in the DA's office at the same time that Walsh was drafting the motion for new trial and the defendant's direct appeal. So I try to argue that that relationship created an actual conflict. And if the court disagrees and says, well, no, it's not an actual conflict, perhaps it's a potential conflict, what's the prejudice? And here's where the circular situation comes in. The prejudice is that Walsh, because of his situation with Ahlstrom, did not raise the prior relationship between himself and Dillon. So with all due deference to the single justice, it is impossible in the posture of this case to separate the two relationships. And
Well, wait a minute. The prior relationship with Dillon, if I'm correct, ended 17 years before.
right.
So that's quite some time ago.
Right, but I would suggest, Your
Like
Honor, and I
ancient
anticipate
history.
the question, it was a question that the single justice and I discussed at length. There's no bright line in a conflict situation. If there was a conflict years ago, there's no case law that says that somehow that conflict is dissipated by the passage of time. And matter of fact, as I sat here this morning and what I was thinking about the situation between Walsh and Dillon and then Walsh and Ahlstrom, I say each conflict is an unconscionable situation. It is unethical, and most crucially, it wasn't disclosed to the defendant or to the court. It should not have happened. So when you
If
look...
you're asking us to write some rule that goes back 17, 20 years, then given the fact that people meet people in the same circles, we're going to disqualify an awful lot of people from both defense and prosecutors from handling cases.
But we're not talking about a casual type of relationship. We're
But
talking...
we could, but it could be. I mean, it
could be, but it wasn't, because if you have my affidavit, Your Honor, in support of the first motion for new trial, I did not use the word intimate casually. I interviewed Walsh. Walsh told me in no uncertain terms that he and Dillon spent the night together. That doesn't imply a casual relationship. Later on, after we were appeared before the single justice, I obtained the affidavit of Attorney Schubert, and the inference there is that they lived together. More importantly, as was the situation in Crokin,
Who was that? Who lived together?
I submit to Your Honor that Walsh and Dillon, based upon Attorney Schubert's observations of the two of them entering and leaving an apartment building in the morning and the evening, there's some inference that they lived together.
But let's see if let's go back to basics. The most you get here is a new appeal, correct?
Well, I would say, Your Honors, what I'm asking for on the first request is reverse the conviction. And
how can we reverse the conviction because he had a relationship with Ahlstrom that occurred after the trial finished?
Well, I ask that you look at the Ahlstrom relationship as the reason that he didn't raise the Dillon relationship.
On appeal.
Exactly. And that relationship the Dillon-Walsh relationship is either an actual conflict or it's a potential conflict.
Let's play that out. So
If it's
let's assume we're focused here on the alleged conflict caused by his relationship with Ahlstrom. You claim that because of that relationship with Ahlstrom, he failed to raise certain issues on appeal, correct?
He was precluded from raising them, but in effect, he couldn't raise his own ineffectiveness. But
okay, but the problem, of course, is that unless it's an actual conflict, if it's a potential conflict, Judge Sossman has already said that the relationship with Dillon would not be sufficient to warrant a new trial, that does not raise a substantial issue. So how can you prevail on a showing of prejudice because he failed to raise an argument which Justice Sossman says falls short of showing?
For several reasons. Judge Sossman did not have the benefit of the Schubert affidavit or the two later affidavits that I obtained from Dr. Harper, the reconstructionist who reconstructed the scene of the murder based upon the blood splatter evidence. In addition, I would pose this to the court. Unlike the situation in Crokin, here you have the information that was missing in Crokin. You know that there was a relationship between Walsh and not some distant assistant district attorney in the DA's office, but the very prosecutor who prosecuted the case. You have the information from my affidavit, and most crucially, what is not denied by Walsh or Dillon, that they did have a relationship. And neither one of them, in the face of my accusation that they had an intimate relationship, says that it was not a intimate relationship. They try, in my view, to camouflage, to disguise the issue by calling it a dating relationship. But I would submit to the court, you can call it a dating relationship, you can call it a romantic relationship, or you can call it an intimate relationship, is the fact that in a first-degree murder case, the attorneys on either side had some type of intimate relationship prior to trial.
But
if I may, Your Honor, one last
okay.
sentence. In Crokin, Judge Spina talks about the import of that type of relationship when he said that such an intimate relationship has irreducible emotional and moral dimensions, and it heavily bears on how any orders of human, how the ordinary...
17 years later. 17 years later.
17 years later, it's correct, Your Honor. But look, if you might, look at it this way. In any relationship, as a dissolution of a relationship, there are emotional effects of the dissolution. You magnify that to either a marriage or a intimate living relationship. Would this court sanction that type of representation in a civil case, in a criminal case, or in a first-degree murder case? At the very least, it should have been brought to the defendant's attention. And both parties had the duty as officers of the court to inform the defendant and the court of what was going on. And the defendant certainly, as he alleges in his affidavit, would not have agreed to be represented by conflicted counsel. The defendant had no way of knowing, did not know, and similar to the situation in Crokin, he inadvertently finds out about the situation after the trial, after his motion for a new trial is denied, and after appeal, by my conversation with him, and we spoke about the trial, and he said, I think they were somewhat friendly. Well, why do you say that? Well, he thought someone said they had once gone out together, and that led me to Walsh, and Walsh, as I state in my affidavit, states they had an intimate relationship. In my view, that should be the end of the inquiry. That should give the defendant a new trial. In the alternative, you give the defendant an appeal. But if you give the defendant a new appeal, we're back where I stand today, because what would be alleged in the new appeal is the Dillon-Walsh relationship. So in that situation, we're back at the same spot. The third alternative is to remand for an evidentiary hearing, which was what was done in the Commonwealth versus Crokin. The issue that I pose to the court is, will this court sanction a situation where there are attorneys on opposite ends of a case that had a prior relationship, putting aside the passage of time, whether it's a civil case, a criminal case, and especially a first-degree murder case. And as I stated in the brief, there's no case in this country, recorded appellate decision, that has a situation as egregious as this situation. There were two other situations where the attorney had a relationship with a police officer, or the attorney and the prosecutor had a one-night stand, so to speak. Here, we have a living relationship or a long-term relationship with the prosecutor and the defendant, and there's no case, the prosecutor and the trial counsel, and there's no case directly on point. Playing devil's advocate in response to Your Honor's question, does the passage of time dissipate that relationship? It's not a casual relationship. It's much more than a casual relationship, and I would say that you don't know. You cannot know if the passage of time in itself negates the conflict. Does the passage of time negate the conflict when it's a conflict where defense counsel represented a witness years ago? If I appeared before a judge and I represented in a first-degree murder case a witness for a conflict years ago, and it was 17 years ago, would the passage of time allow me to stay in the case and represent the defendant? And I would say most judges would probably not allow me to stay in the case, even where I had obtained waivers from the defendant and the witness. And it's magnified when it's a situation such as this situation.
How do you respond? Somewhere it was pointed out that Mr. Walsh critiqued severely Ms. Dillon in his appeal.
He did, and that's what the trial judge found on the motion for new trial. However, there were issues that should have been raised that weren't raised, and if you look at the Dillon-Walsh relationship, if it's a potential relationship, it takes some pains to explain how crucial it was prior to trial that he had consulted even an expert on the blood splatter evidence, and that.
But those are claims that always one attorney can make about another attorney after trial. It doesn't seem to me that that has is affected by the relationship. Well, it's more the personal, and when he critiques her, then that would seem that the relationship is ameliorated. That he didn't do some things during trial. You can say that about every defense attorney.
Certainly, but look at the chronology here. A year before trial, Walsh is told that there's some type of a forensic investigation, doesn't get the report. 5 days before trial, comes in to complain that he got the report at the last minute. The judge disagrees, trial is not continued, still does not get an expert, then comes in afterwards in a motion for new trial, complains about that. Why did he delay? Would an ordinary fallible lawyer, in the context of a first-degree murder trial, in the confines of a small room where the crucial evidence is the blood splatter evidence, wouldn't an ordinary fallible lawyer at least consulted an expert, got some interpretation of the blood stains in the room to support the defendant's defense? That's
an ineffective assistance of counsel claim. But that's not a claim of conflict.
It's all interrelated, Your Honor. Because of the relationship, how do we know that he was saying, well, you know, I went out with Diane Dillon X number of years ago. She would never withhold anything from me. She would never do anything improper. We have a close relationship. She'll give me what I need. It is too suspect, and it is unknown, and it should not have happened. It should not have been in a situation where an attorney has to be in that situation where he had a prior relationship with the DA. It's not, once again, it's not someone else in the DA's office. It's the very prosecutor. And I ask Your Honor to look at it also in this situation. I, luckily, have been in the same marriage for years and years. But in a situation, an intimate situation, an intimate relationship that is over for one reason or another, it is contrary to human nature that there's not some residue of feeling as a result of the dissolution of that relationship. And I'm not saying that every time an attorney has a casual relationship with a prosecutor that means that the attorney is disqualified. But no, in a situation like this, much more egregious than Crokin, it should not have happened, and it should have been disclosed. And as an officer of the court, the parties had a duty to say that divulge it to the defendant and the court. It just seems unconscionable as an officer of the court, having tried cases, that relationship existed and neither party saw fit to withdraw. And as Judge Spina said, those type of emotions are irreducible. If the defendant has to show prejudice, the prejudice at the second go-around on the second motion for new trial was that trial counsel should have, at the very least, as the ordinary fallible lawyer, should have consulted an expert, especially when it's a self-defense. And when you look at Dr. Harper's affidavits, that evidence would have proven, in my view, and as I stated in the brief, would have proven the defendant's actual innocence. And lastly, actual innocence does not have a procedural bar, regardless of the time period. In conclusion, just one more minute, what I ask the court to do is to either reverse the conviction, because it's undisputed that Dillon and Walsh had a relationship, that was an actual conflict. Alternatively, it was a potential conflict, or grant the defendant a new appeal, but we'd be back here again raising the Dillon-Walsh relationship. And the third alternative, remand for an evidentiary hearing. There's a motion for bail. The defendant has been incarcerated for 15 or so years. Allow him out on reasonable bail pending appeal. And I also ask that if it is remanded, that it be remanded to a judge other than the trial judge. Thank you, Your Honor.
Thank you, Mr. Glosberg. Ms. Montori?
Thank you, Your Honor. May it please the Court, I'm Jane Montori, an Assistant District Attorney representing the Commonwealth in this matter. And I'd like to direct the Court's attention to several procedural issues in this case. The first and most important being that the defendant has raised the issue of the conflict between Attorney Walsh and Assistant District Attorney Dillon in two separate motions for new trial. They have both been rejected by single justices acting as gatekeepers. So I would suggest that if this Court were to address this issue now, that the Court would be negating the function of the gatekeeper. Justice Sussman rejected this when she reported the question that is now before the Court, and Justice Spina rejected this more recently in 2008 when defendant filed a third motion for new trial attaching the affidavit of Greg Schubert. And I will.
He's saying that they're inextricably bound and that you can't really look at one thing without factoring in the other.
You could say that about any case that's in this procedural posture, Your Honor, where a gatekeeper has rejected a defendant's claims, and then they bring this in this posture that appellate counsel was ineffective. I think the Cook case is a prime example of this Court saying you just can't do it. You can call it whatever you want, but you can't do it.
Ms. Montori, do you question that this was new evidence in that came after the direct appeal, the existence of this relationship?
It was new. Justice Sussman found it was new, but she did not find it was substantial mainly because it was 17 years. It had ended 17 years before this defendant's trial.
Do you think that we should have a rule that if one has had a significant intimate relationship with someone, that the defendant has no right to know about that when the person with whom you have had the significant intimate relationship is the prosecutor?
I think that a lawyer is ethically bound if he thinks that this old relationship will materially influence his representation.
We rely on him, or we would ask that he inform his client of that. I wouldn't say that, I mean, any significant relationship that of this kind. This is a man on trial for his life. I mean, it's for homicide.
And I would also like to point out that Attorney Walsh was co-counsel. Lead counsel was Attorney Bryson in this case.
Initially, but is it not the case that after a while Walsh took over?
He only took over after the conviction. He did the first motion for new trial, and I would like to point out that the record shows that he did not have any kind of relationship with Assistant District Attorney Ahlstrom at the time he filed that first motion for new trial.
Was that in your brief, that the lead attorney was Mr. Bryson?
It's in the
I saw it in the affidavit.
proceedings.
I thought that he filed some, even during the trial, that there were some of the papers that he filed over his signature alone.
I think that there were some motions during the trial. I mean, he was clearly co-counsel, but I believe that the bulk, if not all, of the direct and cross-examination, definitely the closing argument, was made by Attorney Bryson. Mr. Bryson was the first attorney hired in the case, and he was, if you examine the transcript, lead counsel.
Now, focusing on ADA Ahlstrom and their relationship, do you agree that that was a potential conflict?
Yes.
All right. And what do you say is the line between an actual conflict and a potential conflict with regard to these relationships?
Well, I think you have to look to the nature of the relationship. Here, it was a dating relationship. They only saw each other on weekends.
Was it an intimate
not
dating
anything that
relationship?
led to
Was it an
marriage.
intimate dating relationship?
No. And Attorney
are we supposed to be
Ahlstrom's-
inquiring into whether they're sleeping together to determine whether it's a
Well,
conflict?
I'm just referring to Attorney Ahlstrom's affidavit, I believe the last paragraph.
But in terms of us drawing some line, both in these cases and for the guidance of defense lawyers and ADAs, where do you say that line is drawn between a potential conflict, when does that be created, and when does an actual conflict get created?
I think the Crokin case, which Justice Cowan authored, provides that guidance. I think that a relationship in that case where they lived together, and they had lived together for some time, it resulted in their marriage. Again, in this case, they did not live together. They did not see each other except on weekends, and that this was not the kind of intimate equivalent to marital relationship that poses problems that rise to the level of a conflict of interest.
Okay, so you're saying that there's not even a potential conflict with regard to Ahlstrom, or that there is a potential conflict but there's no prejudice?
There is a potential, although if you look at what Judge Ford said, that and his language was quite to the point, that Attorney Walsh had no difficulty in lambasting Attorney Dillon during the appeal. And if you look at the fact that Attorney Ahlstrom had nothing to do with the preparation of the Commonwealth's brief, she and Attorney Walsh never discussed the defendant's appeal. She knew nothing about the
Would it
defendant's
have been
appeal.
appropriate for them to discuss it?
Pardon?
Would it have been appropriate for them to discuss it?
No.
So we have her affidavit, and I guess I have no reason to challenge it, but doesn't that go to the heart of the problem? I'm looking at it from the defendant's point of view. You've got an ongoing appeal, correct?
Yes.
At the time.
But Attorney Ahlstrom did not handle the Commonwealth's appeal.
Doesn't matter. It's the office.
But she didn't discuss it. In that respect, this is similar to the Crokin case.
Correct.
Where they did not discuss the appeal. No client confidences or secrets were revealed. Attorney Ahlstrom, Assistant District Attorney Ahlstrom, had played no part in preparing the Commonwealth's brief and never discussed the appeal with Attorney Walsh. Her knowledge of this case came from this court's opinion when it was released.
What am I to make this? I never read any paperwork in regard to the Stote appeal, nor did I participate in the preparation of the Commonwealth's brief. What am I to take from that? That she did have discussions about it?
No, I think there's another portion of her affidavit where she clearly says she didn't discuss it.
I'm not talking about with him. I'm talking about in the office.
Well, and Attorney Dillon, who did prepare the brief, I believe, says in her affidavit that
No, I'm concerned with Alstrom. I was
she
struck.
didn't discuss it with Alstrom.
No, I'm
And Alstrom also says somewhere else that her only knowledge of this appeal came from this court's opinion.
Is
which-
all, I don't seem to have Alstrom's affidavit. Is that in your red?
Yeah, it's,
Yes, it is, Your Honor.
Oh, I couldn't find it.
no, it's in the white,
okay,
It's
all
at
right.
page
305.
234 of
She
the
in the appellate
Commonwealth's
section or the trial section of the?
She was in the appellate section at that time.
And the relationship that she had with Walsh, did they go out to dinner alone together?
Yes.
Did
Yes.
They went out to dinner alone?
On weekends.
Okay. And did
She-
they go to each other's homes alone together?
That's not clear from the affidavits. She does say in her last paragraph, she resents the relationship as an intimate, romantic relationship.
Regarding,
She may resent it, but she didn't deny it.
Well, I take that to mean that
No,
she
but you can
denied it.
you can deny it. It's an
And that's what
affidavit.
Judge Ford, I mean, the only parties to this were ADA Alstrom, ADA Dillon, and Attorney Walsh to these relationships, and they all submitted affidavits, which Judge Ford credited.
regarding the relationship with Dylan, now, that was an intimate relationship? I mean, did they live together?
No, they did not live together. They each had separate residences, and that can be found in Assistant District Attorney Dillon's affidavit and Attorney Walsh's
They
affidavit.
have an intimate relationship.
I don't know from these affidavits. There's no reference to whether it was intimate or not, but it was over 17 years before this defendant's trial. And again, I would suggest that that is not before this court because of the rejection of this issue by two separate single justices who were acting as gatekeepers from the defendant's petition under 278-33E.
But I appreciate that fact, but if the issue before us is the potential conflict or actual conflict with respect to the appeal, and the appeal is an appeal from the trial, and the trial, according to the defendant, was rendered problematic because of the actual or potential conflict of the trial attorney and the prosecutor, isn't Justice Ireland right that these things are inextricably intertwined? I mean, how do we draw a line there?
Well, I think if it hadn't gone to the gatekeeper, then they would be intertwined, but because they've been rejected by two gatekeepers, I don't see that. I mean, and they rejected them substantively, not just saying that they were waived. I don't see how this court can consider them. And even if this court were to consider it, there is no actual conflict because of the 17 years that had
So
passed.
it's the passage of time. After that many years, there wouldn't be any residue.
That's correct. I believe that at least ADA Dillon was either engaged or married to someone else, obviously, at the time of this defendant's trial. And as someone pointed out, you know, a lot of these towns are small towns, and the legal community are small. And if
Doesn't mean to say that defendants have any fewer rights that have to be
absolutely
protected.
not, but if you're going to
All that's
say-
required is disclosure to the client. That's all that's required.
It's required if the attorney thinks that it will materially interfere with his representation. And I think based on what happened here, what each party knew about this 17-year-old relationship, and also, and that's addressing the relationship between Walsh and Dillon. As far as the relationship with between Walsh and ADA Ahlstrom, I don't think it rose to the level of the kind that would produce divided loyalties.
You know, I think you said there's no disclosure required unless the lawyer thinks his representation would be materially affected, but that's a basis for withdrawal. I mean, if you think your representation is going to be materially affected, disclosure doesn't cure that.
I was referring, I believe, to Rule 1.7, which is the conflict of interest rule.
Yeah, and I was just reading Crokin. If he concluded that it would have been affected, he should have withdrawn. If he determined he could represent the person without it being affected, he should have sought consent. Right? Isn't that the rule?
Right.
I mean,
But I think you, again, have to look to the nature of the relationship. That's where you start the
Understood.
investigation.
but are you saying that there could be a potential conflict as a matter of law and yet no obligation of the attorney to inform the client?
I think it has to be decided on a case-by-case basis.
It cannot
as
be
Crokin
decided by the
says.
attorney. If there's a potential conflict, it cannot be decided by the attorney. You have to advise your client. I mean, that is fundamental. There's a potential conflict. It's not for the conflict is to protect the client. Oh, it's all over. It may well be all over.
Well, and I think that the ethical consideration has to be separated from the standard, if there is a potential conflict, what the standard is for granting either a new trial or a new appeal, and it's the same standard that's applied to claims of ineffective assistance of counsel.
Can I ask you just a basic question?
Sure.
You've got the same lawyer doing the trial and the appeal. Then you have, after that, you have, subsequent to the rescript, you have motions for new trial. And that's what we have here.
Yes.
Is this the first motion post-rescript?
Actually, there were two, Your Honor.
But this is an amended one? Or
The one that's
whatever?
before the court is the amended second motion, so it was
And-
the first.
Within the motion for new trial, there is an ineffective assistance?
There
of-
were many ineffective assistance of counsel
So
claims, Your Honor.
that's a new issue, and it's not before us because the single justice decided the ineffective issues were not substantial? It's new because the same lawyer obviously represented the person at the trial.
Well, all of the issues that the defendant now claims were based on ineffective assistance were presented to Judge Ford either in the second motion for new trial or the third or both. And they were all rejected by the single justices.
Okay.
For example, the issue of blood spatter. That was raised by Attorney Walsh in the
Direct
first
appeal,
motion.
I understand.
And then it was raised in the second motion. Justice Sussman rejected that as the gatekeeper. It was also raised in the third motion. Justice Spina rejected that as the gatekeeper. If there were a new issue out there, such as, for example, an error in the self-defense instruction that hadn't been raised anywhere before, then perhaps that would be the basis for the new appeal. But there isn't anything that has been raised by the defendant that hasn't already been addressed at least once before. And also this court, some of the issues that he raises, this court had 33E review of the instructions in the closing argument and declined to act upon that. If the court has no further questions, I would ask that the denial of the motion for new trial be affirmed.
Thank you, Ms. Montgomery.
Thank you.
All rise. Hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Boston within and for the Commonwealth, at present depart and give give your attention that this place, Thursday morning at 9 o'clock, to which time and place is saying this court is now adjourned. God save the Commonwealth of Massachusetts.